All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Mr. Court Officer, you may call the case.
Good morning, Your Honors. This is the file number KCBC 2020-06. The Specialist Prosecutor versus Thaçi, Kadri Veseldi, Recep Selimi, and Jakub Kasnici. Thank you, Your Honors.
Good morning and welcome, everyone. I note that the accused are all present in court today. Today we will continue hearing the closing statements in the case. We will hear the response from victims' counsel. Thereafter, we will hear the comments by the defense teams to the SBO's responses we heard on Monday, and statements by the four accused pursuant to Rule 135, Paragraph 4. Finally, unless there's any objection, we will proceed with the closure of the case pursuant to Rule 136. We will follow the agenda set out in the panel's order on the closing statements, which is filing F03639. However, as the SBO concluded its response on Monday, there should be no need for an extended hearing day, as initially foreseen in our F03639. Therefore, today's hearing will conclude no later than 16:45. We will take a break at 10:30 of approximately 15 minutes. And resuming at 10:45, and then a half hour for lunch at 1300. In the afternoon, we'll take a break if necessary, and we will make adjustments during the day as needed to the time schedule. I'm thinking we will probably have the accused statements after lunch so that it doesn't get interrupted and they can get the full attention of everybody at that time. But we'll see. Before we start with the closing statement, there is one preliminary matter the panel wishes to address in relation to transcript reclassification. The panel notes that there are a number of transcript reclassification requests pending before the panel. The panel would like to hear from the parties and participants whether they have any objection to the case closing while transcript reclassification requests are pending. First from the SBO.
No objection, Your Honor.
Victims' counsel.
No objection, Your Honor.
No objection from the Thaçi defense.
None from Wassili, Your Honor.
No objection, Your Honor.
No objection, Your Honor.
All right, that will be the practice then. This concludes the remarks from the panel. We will issue decisions on the pending request for the transcript reclassification in due course. We will begin now with victims' counsel statement. Mr. Laws, you asked for approximately 15 minutes. Please proceed when you're ready.
Thank you, and good morning, Your Honors.
Morning.
First of all, today I'm going to address some points made by the Selimi defense in their submissions last Friday, and then I'll turn to submissions made by the Kasnici defense on Monday. The first matter that I want to address is the issue of causation and victims' counsel's role in relation to it. And we have just a couple of slides to assist this morning, and with the court officer's help, please, if we could have our first slide on the screen. All three slides can be shown to the public. Thank you. If we could move to slide 2, please. At the top of the page, we have an extract from the transcript at page 28908 from the Selimi submissions last Friday. The Victims' Council's submission also relies heavily on emotionally compelling narratives which, while serious and deserving of recognition, repeatedly fail to establish a legally sound and individualized link to the crimes charged. Not on the screen, but in the transcript on the following page, 28909, this was said. Against this backdrop, the trial panel is left not with the question of whether suffering occurred, but with whether the evidence can legally connect that suffering to the crimes charged and to Mr. Salimi personally. So the Salimi defence appears to be proposing two things. First, that we have failed to show a link between the harm suffered by the victims and the crimes charged. We'll address this in a moment while responding to the defence remarks on the expert evidence. Second, that we have failed to establish a link between the crimes and Mr. Salimi. Our response to this second point is twofold. One, that there is no legal requirement for us to establish a link between the crimes and Mr. Salimi, nor any of the other accused, not at this stage or indeed at any later stage of these proceedings. Secondly, as a result, we were certainly not trying to do anything of the kind, namely attempting to prove a link to Mr. Salimi, and so the criticism that we have failed to do so is misplaced. What we have done is to put information and evidence about the harm of the victims before the court. That is what is required of us. It is not our job to prove the case against Mr. Salimi. That is the prosecution's role. And we certainly were not attempting to do so with the evidence adduced from the experts. The position is this, we submit: in the event that any of the accused are convicted, then in order to establish their liability for reparations, what is to be proved is a link between the harm and the crime for which an accused has been convicted. In particular, it is not the law that a link between an individual's conduct and the harm has to be proved. That was the argument put forward by the Charlotte defence in Case 4 before the trial panel and before the Court of Appeals panel, who rejected it on the 29th of January this year. And that's filing in Appeal Case 3, F73. The Charlotte defence, like the Salimi defence, argued that it was necessary to show a link between the acts of the accused and the harm of the victims. We can confidently say that that is not the law, and the citation on the screen at the moment from slide 2 shows that. The appeals panel observes that the causation standards set out above, beginning with Article 22(1) of the law and Rule 2 of the rules, and irrespective of whether factual or legal causation is concerned. Sorry, we're still on slide 2. Thank you. Whether factual or legal causation is concerned, require a link between, and here are the key words, the crime and the harm. Not the conduct of the accused and the harm. The appeals panel considers that the ordinary meaning of Article 22(1) of the law and Rule 2 of the rules is clear in this respect. Thus, reparations are to be awarded based on the harm suffered as a direct result of the commission of a crime within the jurisdiction of the specialist chambers, in relation to which a person has already been convicted. The appeals panel also observes that this interpretation is consistent with the well-established jurisprudence of the ICC. In other words, the link is not between an accused and the harm suffered, but between a crime of which he has been convicted and the harm suffered. Importantly, in a joint enterprise case, that can include individual crimes in which the accused was not a direct perpetrator. See especially para 160 of the Shala reparation appeal decision. My next topic this morning does take us on to slide 3, with the court officer's help, please, and it's the purpose of the expert evidence in case 6, the expert evidence adduced by Victims' Counsel. Slide 3 again has the Salimi submission on this topic from Friday at the top of the page. The expert evidence tendered by Victims' Counsel was incapable of establishing a causal nexus between the crimes charged and the harm alleged, not because the experts were dishonest, not because the defence sought to deny trauma, but because the experts themselves repeatedly and expressly disclaimed the ability to determine causation, attribution, diagnosis, or perpetrator-specific linkage. That submission effectively repeats earlier submissions made by the defence in writing in this case. See F3251 and F3356. The Case 6 expert report was never intended to provide individual assessments of the harm caused to the victims. It served numerous other purposes, including explaining significant conditions like PTSD and setting the harm of the victims in the context of the relevant research and expertise. In so doing, it is certainly capable of assisting the panel in determining if there is a link between the crimes and the harm. We have made it clear more than once that individual assessments were never intended and were not necessary, and the panel has held that their absence does not render the evidence either irrelevant or inadmissible. And on slide 3 we have an extract from our submission in relation to experts' reports, saying that the IMO report prepared for Case 6 gives context to and provides a fuller understanding of the harm suffered by all of the victims in this case, as it explains the victims' experiences of harm from a professional, psychiatric and psychological perspective. And then to the right of the screen, the panel's decision on the admission of expert evidence from F03451 at para 26. While the experts agreed that to link particular symptoms to alleged crimes would require examining the person concerned, this is not the evidence that was offered in this case. The absence of individualized examinations of victims does not render the evidence irrelevant or the expertise unreliable. The absence of such assessment simply limits the scope of relevance of the proposed evidence and what conclusions could be drawn from it if accepted. It appears to be the case that the defence want to keep repeating that the report does not achieve a purpose that it was never intended for. They are, of course, free to do so, but it is, with respect, not an argument that is going anywhere. Finally, in relation to the Salimi submissions, witness W4444. The Salimi defence took a little time to say to Your Honours that we, in our impact statement, had mischaracterised their approach to this victim in footnote 306 of the impact statement, and that's at transcript 28908. That footnote makes the accurate assertion that the Salimi defence cross-examination of this witness misstated his SBO interview. So just a word of explanation on that. Witness 4444 was beaten unconscious in Cots. In his SBO interview, he was asked a clear question. Was your body hurting? That was after the beating, and he replied, yes. And that's at P703.2 ET, page 24, lines 6 to 7. Despite that answer, the Salimi defence asked this question of the witness. You told the SBO in 2019 that you didn't have pain as such during those 4 days, the 4 days referring to his detention. And that's the transcript for the 9th of November 2023 at 9809. It's not a fair question. It's referring to an earlier exchange in the interview in which the witness himself was obviously not referring to the beating that he had suffered. It put the witness at a disadvantage, and so we pointed that out at footnote 306. But the Salimi defence, instead of apologising, suggests that we are at fault in pointing out their error. It is also, we would say, impossible to see what purpose the question could have had, if not to undermine witness 4444 and the pain that he had suffered. So in our submission, that footnote stands. Finally, a few words in response to the Krasniqi submissions on Monday. And I'm going to be referring to what was said at the transcript at 29045. It was submitted by counsel that there was, quote, a long-standing social phenomenon of stigma against collaborators in Kosovo, that it was part of the pre-existing social fabric, and that it was therefore wrong to suggest that the KLA was responsible for victims suffering this stigma. We respectfully disagree. The fact that there was historically stigma attached to alleged collaborators is logically not a bar to victims suffering from the stigma of being accused by the KLA of being a collaborator. Rather, social conditions of that kind provided a perfect background to the KLA's use of the label. We deal with this multiple times under the specific heading stigma as a result of KLA crimes in our impact statement, and I'm not going to repeat that material. But I would like to end by saying that it wasn't, quote, a long-standing social phenomenon, end quote, which abducted people at gunpoint and took them to KLA detention sites. To take just one example, it wasn't any such, in quotes, phenomenon at work in the life of W4870. She was publicly vilified. She had people spit at her in the street. She ultimately had no option but to leave Kosovo. This was not as a result of a pre-existing social attitude. It was because a member of her family had been murdered by the KLA during the war, having been accused of being a collaborator, and because she had had the courage to speak out about it. And Your Honour, thank you for the time. Those are my submissions this morning.
Thank you, Mr. Laws. We turn now to the Thaçi defense. You have asked for and received 45 minutes.
Thank you. Before I begin, Mr. President, may I have leave to pass around hard copies of PowerPoints to the panel, CMU, the prosecution, and victims counsel?
Fine.
Thank you.
Yes.
Mr. President, members of the trial panel, last Wednesday, you heard the Thaçi defense make some assertions that go to the most basic questions in any war crimes trial involving political and military leaders. We told you there are no orders from Hashim Thaçi to perpetrators of crimes. We told you there are no reports from perpetrators of crimes to Hashim Thaçi. We told you there is no credible evidence that Hashim Thaçi had a role in preparing or distributing communiques or political declarations. We told you the SPO offers no rational explanation for why the JCE members would have to transmit the alleged common criminal purpose through communiques if the KLA had a functioning chain of command. And we told you that the consensus of evidence of international and insider KLA witnesses was that Hashim Thaçi was not suspected of being involved in war crimes and that he was not suspected of being involved in any alleged policy of targeting so-called opponents. The SPO on Monday had no rebuttal to these basic points. They have no answers. It's not as if they ran out of time on Monday and couldn't cover all important issues. They still had 45 minutes available to them when they ended their rebuttal. They had the time. They didn't have the answers. After being unable to rebut these fundamental defense arguments, the SPO concluded its rebuttal on Monday by claiming that it is the defense that doesn't want you to do your jobs and doesn't want you to be judges. On the contrary, the defense knows you will do your jobs and that you will recognize the consensus of evidence we have described for you. It is the prosecution that does not want you to do your jobs. They want you to do their job. They want you to see if you can make a case that they couldn't make. But as I noted on Monday, the Mustafa trial panel was clear. The burden of proof is on the SPO and the SPO alone, and they have failed. My mentor taught me a long time ago that the cardinal sin of trial advocacy is to overpromise and underdeliver. And the SPO has committed that cardinal sin throughout this trial. They promised fireworks but delivered duds. And it happened again on Monday. You heard the refrain. They did what they said they were going to do, and then they did it. It seemed like the SPO might finally be leading into an explanation of what exactly it is that Hashim Thaçi said and did. But what did they deliver to you on that argument? What exactly, according to the SPO, did Mr. Thaçi say he was going to do? What exactly, according to the SPO, did Mr. Thaçi do to implement what he said? The SPO had no answers. Overpromising, underdelivering. Let me turn to a point raised about meetings where the common purpose was allegedly discussed. Our closing statement last week addressed the SPO's arguments as laid out in their 870-page final trial brief. You are aware of how hard the defense argued during the trial that the SPO should put its case to witnesses, and you are well aware that the SPO's response was always that, quote, we don't have to state our case until our final brief. So the first time we got to see their case was in the final brief, and we addressed that case in our closing submissions. A huge problem with litigating the way the SPO did in this case is that when you hide your case until your final brief, you don't get to see how the other side will attack your case. And so the SPO learned about more holes in its case only beginning last Wednesday with defense submissions. And predictably, the SPO in rebuttal is now changing its case in order to try to plug the holes in the dam. Slide 3, please. One example is the SPO claim in its final brief that the issue of opponents and special warfare was discussed on a recurring basis at General Staff meetings. That's at paragraph 75 of their brief. You see that on this slide. We took you through the footnotes last Wednesday, which only reference 2 meetings, 16 August and 29 December. Slide 4, please. Now in rebuttal, the SPO claims there are many more meetings than the ones they cited to the panel in their brief in this footnote. You are now told that opponents and special warfare were discussed in meetings on 23 July, 12 and 13 November, 20 December, and 30 December 1998. But these meetings were not cited in support of paragraph 75 of their brief. You can check that yourselves. Mr. Thaçi cannot be expected to address evidence that was not cited by the SPO in support of its case in paragraph 75. Now, we all know as advocates that when making written submissions, especially a final trial brief, you cite to your best evidence. The fact that the SPO did not cite to any of these meetings they mentioned only in rebuttal is itself an admission that the SPO does not really believe that these meetings assist them in proving their case. Slide 5. You should note that with respect to the newly referenced meetings in December, the SPO does not allege that Mr. Thaçi was even there, nor could they. Slide 6. With respect to the 23 July meeting, the only discussion was about how the KLA was being targeted for takeover by Tahir Zemai and the LDK, not the other way around. And you've already heard my submissions on that issue. Slide 7. The 12 to 13 November meeting concerning reorganization of the KLA was followed immediately thereafter by Zarapi issuing 1D29 and by the setting up of the military court, which demonstrates a reasonable inference that the purpose of that meeting was not to target civilians, but rather to better protect all persons and to comply with international law, as we explained last week. Slide 8. Indeed, a review of the minutes of the meeting of 12 to 13 November shows that it contains no reference to opponents or special warfare. Finally, we note that in every one of these additional meetings, Bislam Zarapi was at least present, if not presiding over the meeting. Slide 9. Last week, we highlighted the SPO position taken in paragraphs 1431 and 1432 of their final brief that Zarapi was, quote, not part of the General Staff inner circle to which the accused belonged, close quote, and was, quote, not fully trusted by all KLA members, including certain members of the General Staff, close quote, and therefore, quote, such factors would affect the extent to which the JCE members would openly discuss opponent policy with him, close quote. Slide 10. We also note the SPO position taken in its closing submission that Zarapi was, quote, the one General Staff member who did not form part of that group of trusted persons. He was an outsider. That's transcript page 28468. On Wednesday, we then asked the SPO to explain how, in light of those positions, any of these meetings could have been discussions about advancing the common criminal purpose in light of Zarapi's presence in all of them? We heard no answer to that question on Monday. Because they have no answers, it makes no sense.
The interpreters kindly ask the speaker to slow down when reading. Thank you.
11, please. Instead, the SPO on Monday attempted to walk back its position on Zarapi, now aware of how much they damaged their own case by admitting that Zarapi was not part of any JCE. You were told that it is the defense that is advancing red herrings, namely, that it is the defense that is claiming that, quote, anyone not a named JCE member has been specifically determined not to be in the JCE, and that we said Zarapi, quote, could not have known about or participated in the implementation of the common purpose. Slide 12. Taking these arguments in turn. First, it is not the defense that placed him outside the JCE, but the prosecution. We note that the appeals panel, in this case, found that the indictment identifies the alleged JCE members by category with sufficient specificity, but held, quote, the SPO should provide the defense with all information in its possession as to the alleged JCE members, close quote, and stressed, quote, that should the SPO be in a position to identify additional alleged JCE members by name, it should provide such information to the defense. If by now they don't have enough evidence to name Zarapi as a member of the alleged JCE, you can confidently conclude that the SPO does not allege him to be a JCE member, or else they stand in violation of the appeals panel's decision. Second, it is the SPO, not the defense, who told you that Zarapi was, quote, the one general staff member who did not form part of that group of trusted persons. He was an outsider. It is the SPO, not the defense, that produced an organogram to you last week that specifically noted that Zarapi is not alleged to be a JCE member. It was the SPO who said he was, quote, not fully trusted by general staff members, and that such factors would affect the extent to which the JCE members would openly discuss opponent policy with him. There is no other way to interpret those submissions other than that the SPO does not allege him to be part of the JCE. The fact that they now regret those submissions after hearing the defense closing does not make their own submissions go away. It requires an explanation of how the SPO reconciles its position that Zarapi was an outsider to the JCE with its position that Zarapi attended every meeting where they allege the common criminal purpose was discussed. They made no attempt in rebuttal to reconcile these positions because they have no answers. The SPO claims that Zarapi testified he, quote, was aware of the opponent policy. That's at transcript page 29106. This is not correct. At no time, ever, has Bislam Zarapi stated or suggested that he was aware of a policy in the general staff to target so-called opponents for detention, mistreatment, or killing. In fact, the passage that the SPO cited in support of its position was incomplete. Slide 13. Zarapi went on to say in the Milutinovich trial that, quote, I heard from zone commanders and civilians that some soldiers and officers had exceeded their competencies. At that time, I could not do anything because I did not have any function. After I became chief of staff, we mentioned on Monday what measures I took to discipline the Army, close quote. That's P 1356 at page 6051. Members of the trial panel, you know those measures to be 1D29. That is the context of what he said. He never claimed to have any knowledge that any such policy was emanating from the general staff. He never claimed, for example, that he encountered any resistance within the general staff to his order 1D29. Next slide is not for public broadcast. Slide 14, please. Indeed, as I stated to you last week, Zarapi said in 2005 that prior to late November 1998, the general staff had issued no orders on the issue of detentions, and that detentions were a matter that had been handled by the zone commanders. He's been consistent on this point for 20 years. He could not simultaneously have said he was aware of a general staff policy to target collaborators and also have been saying for 20 years that detentions were a matter handled by zone commanders and not the general staff. The SPO did not even attempt to explain to you how you can disregard that evidence from long ago, because they have no answers. This slide may be broadcast to the public. Slide 15. Turning to communiques. The defense told you last week that the SPO has no evidence that Mr. Thaçi had anything to do with authoring communiques or political declarations other than the untested claims of Mr. Salimi in his SPO interview about Communique 59, which are not credible for the reasons we have explained. Indeed, the fact that the SPO has no other evidence of Mr. Thaçi being involved in preparing communiques further discredits Salimi's evidence about Communique 59. Moreover, we told you last week that the SPO does not even have evidence of someone having a hearsay recollection in a book, unpublished manuscript, newspaper interview, contemporaneous note, and the like of Mr. Thaçi being involved in preparing communiques. The SPO in rebuttal did not dispute that assertion. You may confidently conclude that there is a reasonable interpretation of the evidence that Mr. Thaçi was not involved in the preparation and distribution of communiques and political declarations. We also told you that there is no evidence of any temporal or geographic nexus to any communiques and charged crimes. It was indeed remarkable that the SPO still failed to explain in rebuttal, in simple terms, the actual evidence it relies on to establish the nexus. What is the link between Mr. Thaçi and communiques? We still don't know. Which of Mr. Thaçi's public statements significantly contributed to the charged crimes, and how? We still don't know. Instead, we heard a citation of exhibit numbers being read out one after the other. And this is not because the SPO ran out of time. This is deliberate. Rather than reading from the evidence itself, the SPO chose to give you a list of exhibit numbers, which you are then required to dig out and piece together like a puzzle. Prosecutors who have the smoking gun evidence spend a few minutes reading that evidence to the court. One famous example of this practice is the trial of Radovan Karadzic, where the prosecution established Karadzic's criminal intent by quite rightly quoting Karadzic giving a speech in the Bosnian parliament referring to Bosnian independence as a highway of hell that would risk, quote, the disappearance of the Muslim people. Can you imagine the prosecutor in that case standing up during closing arguments and instead of proving Karadzic's criminal intent by reading out his speeches from the Bosnian parliament, the prosecutor instead read out a list of P numbers and told the trial chamber to figure it out themselves? That would never have happened. Why is it happening in this case? Because the evidence doesn't give the SPO the answers they need. The substance of the documents is so weak that discussing them, either in their brief or in closing statements would only highlight the weakness of the SPO's case. The SPO's case at its highest is a patchwork of documents that it has left you to try to sew together. This does not meet their burden. Slide 16. The SPO also continues to claim that the internationals were uninformed about KLA documents and communiques, citing, amongst others, the testimony of witness Clark. But recall the testimony of General Clark about his 3 October meetings with Milosevic, wherein he told him that NATO would bomb his country if Milosevic failed to stop his assault on the Kosovo Albanian population generally and the KLA in particular. Milosevic was certainly aware of the communiques. Kosovo was a province of the FRY, and he had the entire province under surveillance, as you know. It would have been in Milosevic's self-interest to show General Clark, NATO, the contact group, and the UN Security Council these allegedly insightful communiques if he and his services believed that the communiques were making a significant contribution to war crimes and crimes against humanity. The fact that General Clark and Ambassador Hill have no recollection of Milosevic raising any issue about communiques demonstrates that even the Serbian authorities did not see a nexus between communiques and crimes. The SPO raised several straw man arguments on Monday, one of which was that the defense allegedly said that internationals did not see any KLA crimes being committed. The defense never said that, nor did the defense witnesses. The defense said that international witnesses did not suspect Hashim Thaçi to be involved in the commission of war crimes and crimes against humanity. The SPO does not dispute that this was indeed the position of the international witnesses. We also said the internationals did not see communiques as inciting crimes, and the SPO does not dispute this assertion. It is simply not plausible that the international community would not have been aware of the effective communiques if the SPO case were really the only reasonable inference. I mentioned before the cases of Rwanda, Bosnia, and Serbia as examples where the world was almost immediately aware of insightful propaganda. The SPO in reply had no explanation for why it took 20 years to uncover such allegedly insightful rhetoric in Kosovo. Turning to the military court, you were told on Monday that during his SPO interview, Mr. Thaçi distanced himself from 1D29 and the setting up of the military court. But that is not the case. Mr. Thaçi simply stated that by the time 1D29 was issued and the military court had been set up in late November, he had already left the country and he has no knowledge about it. It is undisputed that Mr. Thaçi had indeed already left Kosovo by that time. That in no way means that Mr. Thaçi said he did not relay his conversation with Fred Abrahams to other members of the General Staff, or that he said his conversation with Fred Abrahams did not lead to 1D29 and the establishment of the military court. Slide 18. As for the argument that neither the 28 November order nor the military justice court were aimed at ending the opponent policy or its implementation, we note that this argument was directly refuted by Zarapi, who told you that he issued these orders precisely to provide due process, including to people being accused of collaboration. And you see that on this slide. That's transcript page 17539 to 17540. The next two slides are not for public broadcast. We turn to the case of the 2 Serb journalists, so-called journalists. There, the SPO raises another straw man argument, slide 19, that the defense allegedly took the position that they were stopped because one of them was a suspected war criminal in Croatia and Bosnia. We never said that. As I stated to Judge Bartha on Monday, the fact that one of the so-called journalists is now known to have not only been a combatant in the Croatian and Bosnian wars, but also a member of a notorious Serb paramilitary force, and that they were heading to an area of combat where Serb paramilitary forces were active, supports a reasonable inference that they were acting suspiciously and that they were stopped for military reasons and not to, quote, gain and exercise control over all of Kosovo. We direct you to my cross-examination of witness Burns on this point, transcript page 13690 to 691. The next slide may be broadcast to the public, slide 21. The prosecution on Monday then attempted to address only part of the ICRC report we rely on, but they completely ignore the second part of the report, namely that, quote, it may take time and resources to define and implement effective review procedures. The SPO's position that non-state armed groups must have a fully functioning system of due process on day one is not only unreasonable, but it is in conflict with the ICRC position. Again, as a matter of policy, we encourage you not to set a dangerous international precedent that non-state armed groups should take no prisoners until they have a fully functioning due process system in place. Slide 22. Turning to Chirez. You were told in rebuttal that even if the delegation in Chirez was advocating for disarming, this does not rise to the absolutely necessary threshold for detention. But this does not address our submissions and relates to a question Judge Bartha asked me on Monday. The question is whether the detention was intended to pursue a military objective, even if with an insufficient legal basis for detention, or whether it was a stop intended to gain and exercise control over all of Kosovo. Whether there was a mistake of fact or law in making the stop is beside the point. The SPO's case is not the only reasonable inference, and the defense case provides at least one reasonable inference that it was intended to further a military objective. Slide 23. We note here that the SPO's case centers around an alleged common criminal plan, which is alleged to be running alongside what is a legitimate war effort. We heard Judge Bartha's question on Monday, asking the SPO for help here, how the panel can distinguish acts that were a significant contribution to the common purpose to gain and exercise control over all of Kosovo through the commission of crimes from conduct that merely contributed to the KLA and or to the KLA general war effort. The SPO replied that it depended on context, and then followed up later by saying that we, the defense, had, quote, failed to understand how the scope of the JCE charged can extend to acts which are claimed as advancing military objectives or personal motivations. The SPO then said, people can have multiple reasons for doing something, and that's why motive is generally irrelevant to criminal intent, citing to Thaçi. 4 brief points here at slide 24. First, those Thaçi paragraphs discuss whether there is an additional motive requirement as part of the mens rea requirements for crimes against humanity generally, so they do not support the SPO's larger JCE point. Second, the SPO cannot just assert that there is an alternate explanation other than a military objective. They have to prove this with direct evidence. The SPO is required to prove, for example, that the 2 so-called journalists were detained because of the KLA's alleged goal to gain and exercise control over all of Kosovo through crimes. Third, if the SPO cannot prove this with direct evidence, then they are asking you to draw an inference. Where there is a question of whether an arrest or detention was carried out for a military purpose or in support of the common plan, then the SPO is asking you to draw an inference by concluding it was the latter. But this must be the only reasonable inference available on the evidence. All other reasonable conclusions must be excluded. And the SPO has consistently failed to engage with this exercise in this case. It is simply wrong to say, as the SPO did in reply, that, quote, people can have multiple reasons for doing something, and it's why motive is generally irrelevant for criminal intent. This argument ignores the SPO's burden of proof as set out in Rule 140, Subpart 3. If there are multiple reasonable inferences for why a detention occurred, and one of those reasonable inferences is consistent with innocence, then the SPO has failed and you must acquit. Fourth, the Limai trial judgment explained this well when it separated out the KLA policy that was, quote, linked to its military objectives to target those individuals thought to be collaborating with Serb forces, as opposed to the phenomenon of, quote, Kosovo-Albanian civilians who may have been abducted for other reasons, such as personal revenge of individual KLA members and other motives. And that's Limai trial judgment, paragraph 216. This is the same war as in the Limai case. Motive is not irrelevant, it's the entire point. On slide 25, on Chirez, we again note that the SPO does not even attempt to engage with the question of how the video of the Chirez press conference impacts the credibility of Deadeye's 2014 ULEX statement. Again, you can reasonably conclude that the SPO has nothing to say about it that would refute the defense position. Slide 26. Instead, you were told on Monday that Deadeye stated in 2014 he had produced to ULEX a photograph of himself taken 2 or 3 days after his release. But no such photograph has been produced in this case, and it is therefore not in evidence. The SPO, I suppose, wants you to imagine what the alleged photograph might have looked like, rather than look at actual video of his condition in your possession taken shortly after his release. They tell you, don't let your lion eyes deceive you. Let your imagination do the work. When you hear submissions like this one by the SPO, ask yourselves, is it the defense or the SPO that doesn't want you to be judges and doesn't want you to do your job? Finally, Mr. Thaçi never told the SPO that he had knowledge of, quote, detainees having been beaten. If you reread that portion of Mr. Thaçi's SPO interview, you will see that he is asked a series of questions in which the question is asked whether he knew any of the members of the delegation had been, quote, beaten or mistreated. They were compound questions to which Mr. Thaçi responded, either to having been told by soldiers about a beating or having been told about mistreatment. Mistreatment could mean many things, including verbal abuse or limited physical altercation, such as pushing, shoving, and the like. Towards the end of that line of questioning, the interviewer uses the words mistreatment and beating interchangeably, so that it is not clear what Mr. Thaçi understood as the question. We do know that Mr. Thaçi said he personally did not observe any physical injury on anyone, which is consistent with the Chirez video before you. Turning to the issue of the LDK boycotts, slide 27. The SPO cites no evidence that the LDK boycotted the PGOK because of alleged mistreatment by Mr. Thaçi or anyone else. As we said last week, the SPO cites no contemporaneous evidence of any such position by the LDK and did not cite any on Monday. It is a made-for-trial argument. In contrast, you have contemporaneous evidence that the LDK was boycotting the PGOK because it did not want to split seats equally in the PGOK. Moreover, the LDK was running its own parallel government at the same time as the PGOK, and in fact refused to give up its own parallel government until February of 2000. You heard that through witness Covey. These were the real reasons why the LDK didn't join the PGOK, not because of alleged abuse. And Mr. Thaçi was indeed being meaningfully inclusive. You see on this slide 27 that in paragraph 64 of our final brief, we cited to at least 15 different instances of Mr. Thaçi calling on the LDK to join the provisional government. The SPO in reply challenged only one of them. On the issue of the Personnel Council, slide 28, there is no mention of a Personnel Council in the indictment or in the pretrial brief. ICL case law establishes that an indictment lacking precision may be cured, quote, if the prosecution provides the accused with timely, clear, and consistent information detailing the factual basis underpinning the charge. A mention in the opening statements is not clear and consistent information capable of providing adequate notice, let alone ample notice. We could have asked Zarapi questions on this topic had we had notice, and therefore we've been prejudiced. On Monday, the SPO stated that the accused repeatedly acknowledged their roles as pioneers, as founders, as key members of the general staff, and cited P186 in support of that claim. Slide 29. P186 are unsigned notes from a meeting with several former KLA members where they discussed the history of the KLA. If you flip through these pages, you will see that in the discussion, there in fact is confusion and disagreement among the members as to how the KLA was established and who its founders were, and we have those excerpts on the slide before you. Turning to the issue of whether there is proof of PGOK meetings in the summer of 1999, the SPO disputed our claim that there was no evidence of provisional government meetings, leaving to one side the fact that the SPO referred to general staff records when the defense allegation was about PGOK meetings only. The SPO cited only 3 documents purportedly showing meetings of the PGOK in this period. All of the cited evidence is untested, it was admitted through the bar table, and no witnesses were able to authenticate and corroborate the relevant portions. Turning to the question of whether the common criminal purpose was conveyed through orders, the prosecution argues that the Thaçi defense made a misstatement when we said that the prosecution does not allege that the common criminal plan was disseminated through written orders. But there is no misstatement. Slide 31. Once again, we will show you the prosecution's final brief, table of contents, where they devote an entire section to answering the question of how they allege the common criminal plan was disseminated. You see that on this slide. There is no section that claims that the common criminal plan was disseminated through written orders. Once again, Mr. Thaçi can only be expected to address the SPO case as they made it in their final brief. The next slide is not for public broadcast. Moreover, in rebuttal, the SPO claimed that P1581, an unsigned SPRK witness interview, was evidence of a direct order from the general staff conveying the common purpose. It is extraordinary that the SPO seeks to rely on this witness at all, given his clear credibility issues. Moreover, the witness testified that he did not know if the order was in fact issued by the general staff. He only claimed to know what he had been told by a man who is now dead. More unsubstantiated hearsay. The SPO's reliance on this kind of evidence to substantiate a key tenet of their case is emblematic of their entire case. So the next slide may be broadcast to the public. The SPO next told you that exculpatory evidence was never rejected because it was exculpatory. But we draw your attention again to the case of W04760 and the inability of the SPO to provide any plausible explanation for their withdrawal of that witness, other than that they realized the witness's evidence was too exculpatory. Slide 33. Turning to Sokol Bashota. The SPO claims that Bashota's evidence is, quote, impossible to read as being hypothetical. I told you last week that no ICTY investigator would have failed to ask follow-up questions seeking details of any general staff orders to execute collaborators if they believed Mr. Bashota was not speaking hypothetically. Let me add that the same applies to the SPO. You will note that in his preparation session, The SPO never asked Bashota any basic follow-up questions to establish when, where, or who in the general staff participated in any discussion about executing collaborators. Slide 34. The SPO then never asked him such basic investigatory questions on direct examination. There could only be two reasons an SPO prosecutor would not ask any basic follow-up questions. Either the prosecutor was grossly negligent, which is unlikely, or else the SPO prosecutor knew that Bashota's answers to those questions would likely lead to disclosable exculpatory material. The SPO knows that Bashota's 2006 ICTY statement is of little credibility. Slide 35. It is of even less credibility when one considers the context in which he gave that statement. As I pointed out in cross-examination, Bashota had been approached by associates of the then-accused Ramush Haradinaj before he met with ICTY OTP. He then gave an account that hypothetically placed authority in the general staff for detentions and executions rather than in the zone commanders like Haradinaj, thus giving exculpatory information for the accused Haradinaj at a time when the ICTY no longer had the ability to indict Bashota or anyone else. In reality, Bashota's 2006 statement posed little danger to lead to the prosecution of anyone, given the ICTY's completion strategy, while providing exculpatory evidence for Haradinaj in his trial. So much so that the ICTY OTP did not call Bashota as a witness in the case. Enough said. The next three slides are not for public broadcast. Next, I would like to address the evidence of W04489 and the issue of the witness's pre-existing notes. The assertion was made on Monday that the witness only produced the pre-existing notes to the trial panel on the request of the defense, and that therefore the notion that the witness would lie about an event in a note to herself so she could somehow use it later as corroboration when the notes were suddenly requested mid-testimony defies belief. No, it doesn't. Context is indeed required here. The SPO admits in footnote 3156 of its brief that W04489 had first changed her testimony in her preparation session with the SPO. She brought the pre-existing notes to her SPO preparation session. That's T11538. It is reasonable to infer that she used her pre-existing notes as an aide-memoire to highlight what she wanted to tell the SPO. There is nothing here that is inconsistent with the defense position. Slide 37. The fact that the witness claimed not to know when she wrote these notes, and in fact could not exclude that she wrote them sometime in 2023, only further establishes the reasonable inferences sought by the defense. Slide 38. You were also told that, quote, the circumstances of how these notes came to become an exhibit show high indicia of reliability, especially considering other witnesses who heard the same information from the same person. Curiously, the SPO provided no citation to any such witness who heard the same information from the same person as early as the time in question in the pre-existing notes. We submit the absence of citation was not an oversight. We know of no such witnesses. In fact, as we said, the other witnesses who testified made no claim of ever having heard any such information. Finally and quickly, on the required contribution to the JCE, and I'm loath to come back to the question of the required contribution to a JCE, as we have all had several bites at the apple on this question. But let me say, the SPO accused us in rebuttal of, quote, collapsing a distinction between a contribution to the common purpose and a personal contribution to each crime, and said, quote, the latter is not a jurisprudential requirement. The SPO then relied on paragraph 1535 of the Perlich Appeals Judgment for the proposition that, quote, the accused does not have to contribute to a specific crime in order to be held responsible for it, because a contribution to a JCE may take the form of contribution to the execution of a common criminal purpose. We are confident that you will go to this paragraph of the Perlich appeal judgment and see that the language selectively quoted by the SPO was in response to a specific submission from the accused Stojic, who had argued on appeal that the prosecution was required to demonstrate a direct link between his assistance and individual crimes, namely individual incidents. And this is in the same paragraph the appeals chamber relied on and cited to the Krajishnik appeals judgment at paragraph 659, which says that for JCE liability, it is not required that the accused physically committed or participated in the actus reus of the perpetrated crime. It is sufficient that the accused, quote, perform acts that in some way are directed to the furthering of the JCE in the sense that he significantly contributed to the commission of the crimes involved in the JCE. So we come full circle. We have collapsed nothing. We have never said that the SPO must prove a significant contribution to each specific act of detention or mistreatment alleged in the indictment. But the standard at the KSC, which mirrors the standard of the tribunals, is that there must be a significant contribution to the charged crimes. The SPO has never shown you how to get there. And in conclusion, Your Honors, let me once again ask you to enter a judgment of acquittal on all counts. And I take the opportunity now, in my final remarks, to thank all of the members of the trial panel, as well as our colleagues on the prosecution, the defense, victims' counsel, for the spirit of cooperation and collegiality that was the norm rather than the exception in a nearly 3-year trial. I likewise thank our court officers, support staff, interpreters, members of the registry and defense office, and all of those inside and outside the courtroom who assisted us. Your contributions did not go unnoticed. Finally, I would like to extend my personal gratitude to each and every member of the Thaçi defense team, past and present. Your contributions have been invaluable, and your excellent work and dedication will not be forgotten. Members of the trial panel, it was an honor to appear before you. Thank you very much.
Thank you, Mr. Misitich. Mr. Dixon, will you take your entire half hour? We won't take the break until you have finished so that we don't have to interrupt you, all right?
Yes, thank you, Your Honours. I'm grateful for that.
You'd be finished at about 10:40 using those figures.
Yes. Thank you, Your Honours. Your Honours, in the SPO's reply on Monday, there was yet again very little mention of Mr. Vasili. Until deep into it, right at the end, when Mr. Helling returned to the SPO's faking of the law and facts in one final last gasp to scoop in Mr. Vasili. In our submission, until then, there was nothing, and even then, there was nothing. Nothing at the very, very end for the SPO, because we submit they provided no answer to the fatal challenges we have raised to their case against Mr. Vasili. Instead, they claim, in a somewhat belittling tone, that we have not addressed the merits of the SPO's allegations. Now, that is very rich coming from the SPO as a final word, when all I did last week was go through each nonsense allegation, one by one, for Your Honours, demonstrating that they were plainly unfounded. And I had another 500 slides I could have presented. This is, Your Honours, not some kind of technical defense that we are putting up, as though we are somehow trying to score a cheap point. The defense rests on the most fundamental right in a criminal trial, namely to test, cross-examine the evidence against the accused. There has to be probative evidence presented in court in the first place, and then it must be there for testing. It is the golden thread of criminal law that the SPO attempts to abuse to string up my client. That legal principle is beyond dispute. A court cannot convict someone when the conviction, whether it concerns direct participation or a common criminal plan or superior responsibility. If in any of those situations the conviction is based solely or decisively on untested evidence and rumor. If I spread a rumor, for example, that someone told me, let's say Mr. Patch is the source, he told me that Mr. Halling did something unlawful. Now, whether or not Mr. Patch reduced that allegation to a witness statement, or just told me, or posted it, or whatever, Mr. Halling cannot be convicted on my rumor evidence alone if Mr. Patch doesn't come to court to testify, to be cross-examined. Now, if he does, it's a different matter altogether. Then it comes down to hearing his evidence and his credibility. But it's really as simple as that, Your Honours. But look at the convoluted manner in which Mr. Halling tries to upset that cardinal principle of criminal law in the SPO's very last word on my client's case. The acrobatics in our submission continue, as it seems old habits are very hard to shake. He said, nobody disputes that Rule 144A concerns untested evidence. He went on to say that is why the Shala Appeals Panel considered the European Court's jurisprudence on untested evidence. And he even referred, Your Honours, to paragraph 486 of the judgment in this regard. But then the SPO swings 360 degrees to say this, and I quote, but the provision, this is 144A, by its plain language only covers a subset of untested evidence, namely the statements of witnesses whom the defense had no opportunity to examine. And he says, this is the second part of it, for every other kind of evidence that is not a witness statement, however that is defined, he didn't come back and say exactly how it was defined. The general principles then of Rule 139.3 apply. Now, Your Honours would have noted that the SPO cited no authority at all for that entirely fabricated interpretation of Rule 140. And he did not refer, Your Honours, to the Shala Appeals judgment, which is squarely on point, because it's squarely against him. Paragraph 486, the very paragraph that was cited, and every paragraph before that and every paragraph after that refers to Rule 144A as covering all untested evidence without any exception. That is the rule of this court. Paragraph 486, and I quote, says in terms, it says, the panel interprets Rule 144A as precluding it from upholding a conviction based solely or decisively on untested evidence, irrespective of whether the trial proceedings evaluated as a whole were fair. Irrespective of that, the first stage that you have to look at is, are they relying on untested evidence as a sole or decisive basis for seeking a conviction? Now, Your Honours, in our submission, it could not be more clear-cut. The appeals panel did not narrow the application of the rule to a subset of witness statements with any particular definition. The proper thing for the SBO to have done would have been, as the prosecution, at least to say to your honours, well, the appeals chamber said that. They said that in terms, but we disagree, or come up with some other argument. But no, they just stumble along as though it does not exist. It's just a mere inconvenience for them, the law. And Rule 139.3 that Mr. Helling did refer your honours to could also not be more clear-cut. There's not a get-out-of-jail card for the SBO. I mean, it provides, and I'll quote you, your honours, subject to Rule 144, subject to that very rule, a panel shall not impose a legal requirement that corroboration is required in order to prove any crime or criminal conduct. So, in other words, the requirement of corroboration is always subject to Rule 144, which flatly prohibits, without exception, untested evidence to be used as the sole or decisive basis for a conviction. The two rules obviously have to be read together and applied that way. Now, the upshot of this is that the whole case against Mr. Thaçi is imploded. The direct allegations, as well as those that are circumstantial, come crashing down. For example, it means that when Mr. Helling last Tuesday showed your honours a video clip of W4760 in an SBO interview saying he allegedly heard a story from someone that my client was involved, that is pure hearsay, as the alleged source evidence was not available to be tested. That clip is thus entirely worthless. It was played for some kind of impact, for your honours, because it mentions my client's name, but it is of no worth as a matter of evidence. And as your honours will recall, I was not even able to cross-examine 4760, having opposed the admission of that very clip. And as our brief explains, he would have been shown to be unreliable in any event had he attended. And exactly the same applies to the other allegation of direct involvement, the transfer of the single detainee, and the countless other circumstantial allegations that are relied on. Your Honours, this is not some kind of procedural trick the defence is playing. This is not a game. This is the cornerstone law of testing evidence in a criminal trial, and it has been the law for decades. It is rather the SBO, we say, who are up to their usual trickery here. Indeed, Your Honours, we threw down the gauntlet to the SBO. We said, are you saying for the direct allegations you can rely on untested evidence to convict just because it is not in the form of a witness statement as defined by the court, and expecting them, perhaps naively, to row back from that unashamedly wrong position in law? They did not. Yet Mr. Helling still also did not have the follow-through to go on and apply that wrong law to the allegations of direct involvement and say to your honours, okay, this is how we say you could possibly get to a finding of guilt. A, B, C, D. They did not walk your honours through it step by step. They are still not putting their case because they know it's wrong. They're just hoping your honours will somehow join the dots for them. But there's no way of doing that as a matter of law and fact. Far from the defence wanting your honours not to be judges or don't do your job, as the SPO claimed in a most peculiar twist on Monday. The defense asks Your Honours to do exactly that, to apply the elementary law. In addition, and which the SPO again completely failed to acknowledge, we have dealt at length with the machinations of the whole pile of hearsay regarding these direct allegations, i.e. the merits, which absolutely have no merit. It's a wrong choice of words. See, for example, our brief at paragraphs 233 to 248, and that's 15 pages just on this one allegation, setting out how the hearsay on that allegation is really a mound of trash, which does not show that Mr. Vasili was involved at all, let alone anywhere near where this was all meant to be happening. There's also nothing in the half suggestion that a non-objection to a Rule 55 tender can be a relevant factor when considering such evidence. I couldn't follow exactly what the SPO was trying to drive at, but I do wish to emphasize this, that the Vasili defense clearly objected to the tenders under Rule 155 of 4747, 4760 that I've just mentioned, and 4839. This is the sole witness concerning the Kletschke detention. And in this regard, Your Honour, see, for example, our filing of the 4th of December 2025, paragraph 4, where we state in terms that we oppose the admission of 4670 statement on the basis that it clearly violates Rules 155 and 138. And we sought to appeal that decision as well. I mean, moreover, this is irrelevant, as it was purely hearsay evidence. It's not the source evidence that we're talking about here. And for 4747, our opposition to the admission of that evidence was, of course, also based on the defense's right to cross-examine him. The fact that his evidence was admitted does not change the rule in any way that his evidence cannot be relied upon unless corroborated. And it certainly does not change the brimming portfolio of his lies. Your Honours, we don't even need the evidence we assembled and cited at footnote 62 of our brief that the SPO referred to show the raw deceit of the man. In this regard, see our brief at paragraph 54 for examples of his lies, which are in evidence, such as his claim that he fought for the army of another country, which he simply just didn't do. He made that up. And see paragraph 56 of our brief for examples of the internal inconsistencies and contradictions in his evidence. The full list of his demonstrable lies that are in evidence, we'd ask Your Honours to look at our filing F3147 and its annexes. And all this, not even to mention the sensational allegations which he makes that are uncorroborated. We've set out a list of examples of that at paragraph 55 of our brief. And the same arguments apply to the evidence of 4839. This is the sole witness regarding Kletschke. I mean, he's a proven liar. We set that all out at paragraph 601 of our brief. So it was thus, we say, thoughtless of Mr. Halling on Monday to say that we have not even bothered to explain how witness 4747, for example, was going to be ripped apart if he attended here and gave evidence. The reason we referred to the statements that are not in evidence in that footnote 62 was to highlight the profound prejudice we have suffered from him not coming here to give evidence live. It's not for the truth of its contents. It shows the prejudice, because after all, we are here in the context where the SPO chose to call no one else from his zone. And there you'll see in that evidence statements which were taken inter alia from his very zone commander, his brigade commander. These are all people the SPO could have interviewed and brought. And also a member of a group of fighters in his zone that he makes false allegations against. And as his evidence is untested, uncorroborated, there's no evidence that can be used to support a finding of guilt. And that is why we did not call these persons as witnesses. No burden on us to do so. Even 4747's evidence of being too afraid to attend here comes from him alone. It is not corroborated, and it must be viewed in the light of his litany of lies. Another available inference that can be reasonably made on the evidence is that he did not wish to attend for fear of his falsehoods that we've set out in our submissions would be exposed. What then did Mr. Helling say on Monday about corroboration and the JCE case? Well, Your Honours, in sum, a lot that was wholly wide of the mark and which brought on a sharp grimace when it was uttered. And there are three brief points that I wished to make in this regard. First, the SPO said that collaboration is only required in light of Rule 44A for big picture points, like mens rea, like the JCE. And that is just plainly wrong. As I pointed out last week, the Sharla Appeals Panel overturned findings of crime-based torture, not of the accused involvement, but just the crime base, on the basis that they were based on multiple hearsay accounts alone. I gave examples of that. Predicate findings must comply with the rule as well. Secondly, the SPO said that there's no requirement for the specific fact at issue. But that's exactly what the appeals panel has found in the 4747 decision that I took your honours to at paragraph 36. They said the same fact. It can be different kinds of evidence, but it must go to the same fact. Mr. Helling referred to cases the SPO cited in this appeal, but he did not refer to the key dicta of that decision. According to the SPO, then, what Mr. Vaseli may have been doing somewhere else in Kosovo at a different time, whatever that might be, could be used in conjunction with untested evidence of alleged direct involvement, for example, the transfer of the single person, to support the allegation that he contributed to the JCE. So you can take all the untested evidence on direct involvement and somehow link it together with other unrelated evidence and then come up with a finding that supports a JCE. I mean, that is really just hot air. And the prosecution haven't even tried to show you how you can join all of those dots. It's beyond doubt that each fact relied on that is needed for a conviction has to be corroborated. And using just the example of that one person that was transferred, when it comes right down to it, you honest look at what is cited, each bit of evidence that is cited by the SPO, to try and show that Mr. Vaseli was in the general area at the general time. None of it places him where the allegations occurred, on the specific dates, or anywhere near there at the time. So if they can't even do that for that one direct allegation, how do they expect to use that evidence to show somehow, if they haven't established that, that's relevant for proving a JCE? And then thirdly, Your Honours, the SPO says that defence has underplayed Mr. Vaseli's other contributions. They say we somehow just brush over that. But they don't specify what those contributions exactly are. Your Honours will know I dealt with the two direct allegations and the others that they could be referring to, scooping everything up. And then thereafter, on the broader circumstances, we highlighted the largely undisputed evidence that Mr. Vaseli was abroad for lengthy periods from late July 1998 and into September and October, which included the FARC negotiations abroad, and then from 12 November 1998 to March 1999, after Rambier, without there being any reliable evidence of him being in contact with persons in Kosovo during these extensive times. Your Honours should see paragraph 520 of our final brief for that timeline and the supporting evidence, and of course the paragraphs surrounding it. And even when in Kosovo, as we have shown, Mr. Vaseli attended very few meetings and trips of the General Staff. He was not commanding any functioning intelligence structure, or anyone for that matter. And he was not active in the political directorate. That he was even in it has not been proven, as it only stems from limited, untested evidence. See paragraph 298 of our brief in this regard. But in any event, there is no evidence of Mr. Vaseli acting in this directorate in any way, let alone ways that contribute to him intending to be part of a JCE, having knowledge of crimes within that context. We are not running from our role, as the SBO claim, running from who Mr. Vaseli is. We are showing that it was not a role that was criminal. He was performing his roles, but was not a criminal one. And therefore, don't say, SBO, that we are not dealing with the merits of this case. In fact, accepting that we were absolutely engaging with the merits, it was after I answered a question about being abroad from the bench that the SPO leapt in to say, well, Mr. Vaseli is doomed because his most sustained and direct interaction is in the early months of the indictment, with the command edifice, this is the SPO's words, being set up before the time he is absent from Kosovo. That is a concession, we say, for the first time on Monday, from the SBO, turning to focus now on the early months for command and control. But that is when the levels of organization were logically at their very earliest of stages, and most disorganized, most disjointed. That is the height of horizontalism. There's certainly no proof of any intelligence structure then, with directorates only coming later in November 1998 on a wealth of evidence, and even then without any centralization and connection to the zones. That's the time when Mr. Vaseli leaves and goes abroad. Now, before concluding, Your Honours, we did wish to revert to Judge Barter's question on the state practice to support the customary law for detaining for security reasons. It's an important question because, as Your Honours will know, and I expect this is where the question was coming from, the ICJ's North Sea Continental Shelf case made very clear that state practice must be widespread and representative. Now, we may not be in that realm when we are addressing state practice and when surveying state practice on this issue, but nor are we for the existence of a crime in the first place of unlawful detention in an internal armed conflict under customary law. The appeals panel, inshallah, has, however, recognized that deprivation of liberty can occur for security reasons. And they said in terms that the SPO must prove in a reasoned, clear way that detention was absolutely necessary, with reference to ICTY case law. So there is case law here which has addressed this point, and that's at paragraphs 724 to 734. And the ICRC expert consultations and case study confirm as much, with reference to national legislation, military manuals, and state practice from states and through international organizations. And I refer your honors here to the ICRC Customary Law Case Study, Rule 99, Deprivation of Liberty, Volume 1, on the rules, and the Chatham House ICRC Expert Meeting of 2009, that's in 91 International Review of the Red Cross at 859. In conclusion, your honors, the SPO asserted at the end of their reply submissions on Monday that we divide and conquer when we should be assessing the totality of the evidence. Again, a deeply ironic metaphor associated with occupation to use against us, but more importantly, deeply ill-advised, as the defense is perfectly entitled to show that the core allegations are based on mere rumor and hearsay, including all those 155 statements, and are thus untested and unfounded. And then that what is left is just drivel. Where in the vast universe of evidence is the actual criminal case against Mr. Thaçi? The SPO has not provided any roadmap. They leave it to your honors to try fathom that out for them. It is in our submission lazy, and it shows contempt for the foundation of the court, that it was not established to punish for the sake of doing so, just because a cardboard cutout of a case is put up in a shop window. That is classic divide and rule. Control the false narrative by fragmenting the truth. The court needs, in the shattered pieces that are lying around on the courtroom floor, to find that there is no thread of proof in the mess that is the SPO's case, and to unite behind the truth of Kadri Thaçi's innocence. Thank you, Your Honours, and thank you to everyone.
Thank you, Mr. Dixon. We'll break now until 11, and then we'll come back for the final two submissions by Salimi defense and the Krasniqi defense, and then we will, after that, we'll break for lunch and come back after lunch to hear the statements from the accused. Yes, Mr. Ellis.
Your Honour, if it helps in determining schedule, I'm not intending to use the full 30 minutes. It's more likely to be 20 minutes.
Thank you. We'll, same schedule anyway, though. It will be, we're running a little ahead of schedule as it is. So we will see you back here at 11 o'clock. We're adjourned till then.
All rise. All rise.
Be seated, please. The interpreters have kindly notified me that I misspoke this morning about the lunch break, so I didn't want to leave too much confusion. We will, when we're finished with these next two submissions, we will then break until 1:30 for lunch. We'll be back here, and that'll give us plenty of time for the submissions this afternoon from the accused. I just wanted to make sure that they got to have their time devoted to them so that we wouldn't be interrupting them with things like lunch. So anyway, sorry about that if there was a misunderstanding. Not in my mind, but all right, we will proceed now with the comments from Salimi. Mr. Roberts, you have the floor.
Thank you, Your Honours. Your Honours, this is my last opportunity to make submissions before you in this case in response to the SPO's oral submissions from Monday. However, to be frank, as we've always tried to be with Your Honours, I have a problem. There really is nothing from the prosecution's submissions to which I actually specifically need to respond. Despite having been allotted a full 2.5 hours for their submissions on Monday, the prosecution's arguments and assertions in response to our oral submissions amounted to nothing more than a handful of discrete points that we've already largely previously addressed. Your Honours, to put it bluntly, the prosecution is embarrassed about their case against Mr. Salimi. There really is no other conclusion that can be drawn from both their oral submissions on Monday and their written final brief. If the prosecution cannot even convince itself of its case against Mr. Salimi, how can it convince Your Honours? However, I will simply address a few of these minor discrete points that arose from the prosecution's submissions, not because we believe they advanced the prosecution's case in any meaningful way, but because they actually underscore the fundamental evidentiary and that already permeate it. First, despite extensive and detailed submissions we made on every aspect of the alleged joint criminal enterprise, from its alleged membership, the lawful objective at its heart, the purported means through which this lawful objective was achieved, all the prosecution could respond to us was that the evidence relating to events mentioned in communiques was apparently set out in footnote 6206 of the SPO final brief. But looking at this footnote, this simply actually repeats claims or assertions in the communiques and doesn't actually identify evidence underlying those claims or any support that those claims actually were correct. This is not underlying evidence, but merely repetition of assertions in the communiques. The inability of the prosecution to know the difference between assertions or allegations and evidence is as concerning as it is at this stage of proceedings somewhat unsurprising. But its inability to even address any of the other issues raised in relation to joint criminal enterprise highlights what we say is the lack of clarity and confidence that the prosecution has in its own case. In response to our extensive submissions on the ubiquitousness and irrelevance of the phrase special war, the prosecution stated generally that the accused used the term and then referred to Mr. Salimi's speech during the first public appearance of the KLA in November 1997. Yet this phrase wasn't used at all by Mr. Salimi during the speech, and no other reference to him using it was identified. all other documents cited by the prosecution in court in relation to this concept have such evidential shortcomings that the panel can have no confidence whatsoever in them. As so often, Your Honours, I urge you to carefully check every single document relied on by the prosecution in writing and orally to see if the SBO's lofty claims are sustainable. We would submit on every count that they are not. On the role of Inspector General, the prosecution claimed that although Mr. Salimi didn't have formal authority under the disciplinary regulations, that didn't really matter because those regulations apparently generally authorise superiors to take disciplinary measures. The prosecution also asserted that Zerapi testified that the Inspector General had undefined authority to exercise control, and also referred to a concept paper saying that one of the responsibilities of the Inspector General was to identify, quote, weaknesses. Is that really it? Can the prosecution's case on Mr. Salimi's disciplinary authority really rest on such generic foundations which wholly ignore all of the rest of Mr. Zerapi's evidence, and also the rest of evidence of other witnesses? Do they do this in the vain hope that Your Honours won't notice? It appears that they do. On handwritten notes, prosecution counsel referred to defence submissions as an attempt to expertise the process of determining authorship of these notes. But what the prosecution appears to have forgotten is that the burden remains on it to clearly allege, demonstrate and prove attribution of these notes to Mr. Salimi. The prosecution failed to call any witness of fact, to identify any piece of handwriting from any notebook that the prosecution now attributes to Mr. Salimi. No burden can now be placed on the defence to refute any allegations of authorship based on the evidence before Your Honours. The CISE trial judgment in paragraph 517 specifically criticised the defence for not calling expert evidence where witnesses of fact had created a rebuttable allegation. Yet there is no rebuttable allegation in this case, and the inverse is true. Where the prosecution wishes to establish authorship without a witness of fact, it must present all relevant evidence to establish this authorship, which in this case we say could only be by expert evidence. Again, the prosecution has conspicuously failed to do so. In criticising defence written submissions on some of these handwritten documents, the prosecution erroneously attempts to place the defence and the prosecution on the same footing by obfuscating the clear difference between the parties and their respective burdens, as well as the purpose for which each submission was made. It is not that the prosecution is merely noting similarities or dissimilarities in handwriting, as was claimed. Instead, the prosecution is calling upon the panel at this very late stage to look across multiple notebooks relied upon by the prosecution and to make a firm conclusion on specific authorship of Mr. Salimi, which goes to material issues to be considered in the determination of his guilt. In these circumstances, the prosecution was obliged to have stated their case clearly from the outset about the attribution of these notebooks to Mr. Salimi, and then led appropriate evidence in support. It has failed on both counts. The panel must not be swayed by these late-stage pleas to compensate for its notice failures and evidentiary omissions. In relation to each and every individual allegation of contribution against Mr. Salimi, the defence made extensive submissions about the credibility and reliability of witnesses, inherent contradictions between their accounts, and lack of relevance of their evidence, regardless whether or not the evidence was in favour or not of Mr. Salimi. The one substantive response by the prosecution to these detailed submissions, that they were not formally withdrawing the allegations in Turez against Mr. Salimi. However, even on that one specific issue, we invite Your Honours to view side by side the allegations originally set out in the prosecution pretrial brief against Mr. Salimi on this issue and compare them with how those submissions and allegations are now made at the end of the case. See for yourselves how much the prosecution no longer relies upon. As for the rest of Mr. Salimi's alleged significant contributions to the JCE, the silence from the prosecution is deafening. The prosecution simply did not address direct defence challenges to their own allegations and their own evidence as to Mr. Salimi's alleged contribution to the JCE. There is simply nothing else for the defence to reply to. Now, we did note that the prosecution further addressed the legal issue of the nature of the contribution to a JCE, and according to the prosecution on Monday, this is transcript page 29136, the question is not whether the accused directly caused each charged crime, but whether their conduct significantly furthered the criminal purpose whose crimes are charged. Now, we're not asserting that the contribution needs to have directly caused a crime for it to be significant for the purposes of JCE liability. This is a deliberate distraction by the prosecution. What matters is that the alleged contribution must actually significantly contribute to the crimes charged. You heard from counsel for Mr. Thaçi earlier in relation to the appeals chamber in Perlich on this issue. We say that in this case, the prosecution is implicitly trying to artificially separate the lawful objective at the heart of the JCE from the underlying crimes charged as the means through which that objective was allegedly achieved. It is then saying to Your Honours that as long as the contribution is to the objective, this is sufficient for criminal liability. It is absolutely not. The objective of the JCE is not inherently criminal and can only potentially give rise to JCE liability, if at all, because it was supposedly carried out by unlawful means. We addressed this substantively and extensively last week. As such, the criminal purpose as a whole encompasses both the objective and the allegedly criminal means. Your Honours cannot artificially separate them. Furthering the criminal enterprise requires that the accused contribute directly to the underlying crimes. Now, we say this is one of the many places where the prosecution's case against Mr. Salimi ultimately collapses. The contributions that Mr. Salimi is alleged to have made to the JCE, which the defence has addressed in detail, in writing and orally, cannot be shown to have contributed significantly to the underlying crimes in the indictment. No conviction for JCE can therefore be upheld against Mr. Salimi. That's it, Your Honours. There's no final hidden piece of the jigsaw that the prosecution can suddenly pull out like a rabbit from a hat to suddenly secure a conviction against Mr. Salimi. On each and every allegation against Mr. Salimi in this case, the prosecution's case has been found wanting. Your Honours, after 5 years of pre-trial and trial proceedings in this case, hundreds of witnesses, thousands of exhibits, and the weight of an entire prosecution office behind this case, you would quite rightly have expected the prosecution case on Monday to go out with a bang. However, as we all saw on Monday afternoon, it quite literally went out with a whimper. All I can do now, Your Honours, is to reiterate my request from last week. Mr. Salimi must be acquitted on all charges and released immediately to return to Kosovo with his family. No other verdict can be reasonable or justified on the evidence in this case. Thank you very much, Your Honours. I've tried to be as brief as possible, and I will now end our submissions. Thank you.
Thank you, Mr. Roberts. We now turn to the comments from the Krasniqi defense. Mr. Ellis, you have the floor.
Thank you, Your Honours. I too will be relatively brief because we stand by our final brief and the closing arguments that we have made, much of which was untouched by the prosecution on Monday. There are three discrete points made by the prosecution which do merit a brief reply from me this morning. First, as to the role of Bislim Zarapi. On Monday, once again, the prosecution tried to minimize Bislim Zarapi's role and to rely, we say wrongly, on the submission that after November 1998, Zarapi was subordinate to Mr. Krasniqi. It's remarkable in this regard that the prosecution's case continues to be marked by sustained selectivity. Even in the oral response on Monday, it extracts fragments that suit its theory while disregarding oral clarifications and unchallenged exculpatory testimony from the prosecution's own witnesses. That isn't analysis, it's distortion. And the panel must not be drawn, we submit, into preferring selective excerpts from written documents over the sworn testimony heard in this courtroom. To do so would invert the normal hierarchy of proof and risk a grave miscarriage of justice. Thus, the prosecution relied on certain pages from P189.1 without acknowledging that some of the very pages they cited were put to both Bislim Zarapi and Sokol Bishota, and both highlighted mistakes and exaggerations in its account of roles and responsibilities in the General Staff. That's transcript pages 18,400 to 402 and 230029 to 23031. Then the prosecution relied on P712, which is the diagram put together by Sadiq Khaled Yaha. But strikingly, that diagram only identified Sokol Bishota as the deputy commander and depicted Mr. Krasniqi's role to the side as spokesperson. It is not therefore capable of proving that Mr. Krasniqi was superior to Mr. Zarapi. So the documents relied on by the prosecution in that regard are unconvincing. But moreover, in cherry-picking those documents, what the prosecution ignores and fails to engage with is the overwhelming body of evidence identifying Bislim Zarapi as the Chief of the General Staff, which, as Naim Maloku said, is the highest command position in the army. That's transcript page 26022 to 26023. In brief, what is that overwhelming body of evidence? Well, first, Zarapi referred to himself by the title Chief of the General Staff. That's the references set out in our final brief at paragraphs 581 to 582. Second, Zarapi signed orders as the Chief of the General Staff. That's the references set out at paragraph 583 of our final brief, including orders such as P624, 628, 630, 631, and the list goes on. Third, other KLA members, including former career officers who would know all about military titles, addressed documents to Zerapi as Chief of General Staff. See P1432, P1360. Fourth, witnesses came to this court to testify that Bislam Zerapi was Chief of General Staff. Those are set out in paragraph 585 of our final brief and include Naim Maloku, Sokol Bashota, Rustem Mustafa, 4764, 4739, 3871, 3870, Halil Chodraku, and Kurtesh Fondai. In maintaining that Zerapi was subordinate to Mr. Krasniqi, the prosecution asks you to reject this body of evidence, including at least 9 prosecution witnesses and some of Zerapi's own evidence. That, in our submission, is untenable. And in an unconventional army like the KLA, it can be even more important to look at how the army actually functioned in practice, rather than just looking at those formal titles. And we say that evidence is clear that it was Zerapi who was in charge. From General Staff witnesses, Naim Maloku listed the powers of Bislam Zerapi vis-à-vis the zones and added that only himself, Bislam Zerapi and Salih Vaseli had the ability and skills to lead the General Staff. The others had no knowledge or training. For him, Mr. Krasniqi's position was a secondary one, which he linked to formalizations. Sokol Bashota also testified that orders to the zones were a power of Bislam Zerapi, who had full authority to issue orders single-handed, without consulting anyone else in the General Staff, while Sokol Bashota confirmed that Mr. Krasniqi's position was not recognized by the zone commanders. That's dealt with in paragraph 612 of our brief. And then there was evidence from 3 zone commanders. Suleiman Salimi testified that the person who issued orders to him as zone commander was Bislam Zerapi, whilst on the other hand, Jakub Krasniqi was rejected as deputy commander for support. That's pages 25060 and 25303. Rustem Mustafa testified the requests and recommendations he received during the war came from Zerapi as head of staff. On the other hand, he said he never spoke to Mr. Krasniqi as deputy commander, and the zone commanders as a whole didn't recognize that appointment. That's transcript pages 5833 to 5834 and 5956. Shukri Buya testified that after his appointment as zone commander, he only received instructions from Azam Sula or Zerapi. And at a lower level, there is evidence from other KLA witnesses which makes the same points. They reported to Bislam Zerapi, they did not to Mr. Krasniqi. I have in mind Kurtesh Fondai, witness 4764, 3871, and Sadiq Halit Yaha. That's the record of the case, Your Honours. Aside from the self-serving testimony of Bislam Zerapi, who remained a suspect throughout his evidence, there is no concrete or reliable evidence that Jakub Krasniqi was his superior. To the contrary, he was the chief of the General Staff. And I've chosen to focus my submissions on that matter, not only because it demonstrates that Zerapi's evidence about Mr. Krasniqi was fundamentally unreliable, but because it demonstrates that the prosecution's submissions in the final brief and again on Monday, which looked to limit Zerapi's role, to say that he wasn't part of the inner circle, he was an outsider, he didn't have the same authority as those who were present from the beginning, is simply a misreading of the evidence. Zerapi was at the heart of it and had the authority, and that is why it is so significant that the prosecution say that he's not a JCE member. I turn to deal with 2 brief topics. Second, in relation to the legal sector, we welcome the prosecution's withdrawal of the final sentence of paragraph 567 in their brief, one of the few concessions the prosecution made on Monday. But the evidence that remains is wholly insufficient to prove that Mr. Krasniqi oversaw the legal sector. It's true that Bislim Zarapi testified that the deputy responsible was mostly Jakub Krasniqi, but he was not credible on this point. He remained a suspect throughout his interview and testimony. During the conflict, De Bruyne consulted with Zarapi about detentions, including the Serbian woodcutters and Blum Kuci. That's set out in paragraphs 599 to 600 of our final brief. As a military professional, Zarapi would have been well aware of his potential for command responsibility, and we say that's why he sought to distance himself from the legal sector. His evidence about Mr. Krasniqi was purely self-serving. As we submitted on Friday, and the prosecution did not challenge in reply, Zarapi accepted that he saw no instructions from Mr. Krasniqi to Sokol De Bruyne, and no reports moving the other way from Sokol De Bruyne to Jakub Krasniqi. His evidence cannot support oversight without reporting or instructions. Further, the prosecution's position is directly contradicted by De Bruyne himself, whose evidence was that there was no formal reporting to anyone in the General Staff, that nobody interfered with his work, and that Mr. Krasniqi was not hierarchically above him. And some of that evidence is at P1955.2, page 10, and 1955.9, page 9, and P1963, page 054683 for the record. And my last substantive point, Your Honours, is that in trying to deal with Mr. Krasniqi's alleged contribution to the JCE, the prosecution submitted on Monday that Jakub Krasniqi was in the General Staff. All the accused were. They chose to remain in the General Staff over a long period of time while the crimes charged in this case continued to be committed, in accordance with General Staff communications, orders, decisions, and support. What the General Staff did bears on their individual responsibility. The accused don't have to be identified by name in each piece of evidence to be making a criminal contribution. That was the submission made on Monday. Last week, however, at the opening of the closing arguments, the prosecutor could not have been clearer, submitting at transcript 28266 that no conviction is sought and no sentence can be imposed on the sole basis of being a member of the General Staff or of the KLA. That cannot be squared in our submission with the later submission that being in the General Staff or choosing to remain in the General Staff is somehow determinative of an individual contribution. The panel will be well aware that there may be various reasons for choosing to remain in the General Staff at a time when Serbian forces continued to commit crimes against the civilian population. The whole point of individual criminal responsibility is that the contribution of each accused does have to be identified individually. Because if it is sufficient to rely on membership of the General Staff or on what the General Staff did, then in substance this has become a case against the General Staff. Your Honours, on Monday the prosecution requested you to assess the totality of the evidence. We fully agree. We know that Your Honours would do that anyway without me saying it. But we are confident that when that assessment is done, when documents are assessed together with the witness testimony explaining them, and when the burden of proof on the prosecution is rigorously applied, it will bear out the arguments that we have made, and it will lead Mr. Krasniqi to be acquitted. Thank you, Your Honours.
Thank you, Mr. Ellis. As I stated, we will be adjourned until 1:30 for lunch. So we are adjourned until then.
All rise. All rise.
Please be seated. We will now hear the statements of the accused. Each of the accused has been allocated 20 minutes for their statement. The statements should focus on and be limited to matters that are relevant to these proceedings. I also ask the accused to speak at a slow pace so the interpreters can translate your statements. So we begin first with Mr. Thaçi. Mr. Thaçi, you have the floor.
It's okay, thank you. In the royal
Honorable Presiding Judge Smith, Your Honours, honourable participants, greetings to everyone who's following these proceedings from the public gallery. Yesterday, they celebrated the 18th anniversary of the independence of the Republic of Kosovo. Feeling the heartbeats of our ancestors, we declared Kosovo an independent and democratic state on the 17th of February 2008. And from this room here today, I wish to convey my warmest congratulations to all the citizens of Kosovo on this magnificent holiday. Your Honours, for nearly 3 years in this courtroom, you have heard the allegations of the prosecution as well as the arguments of the defence. You have seen the facts. You have heard the truth. There is, however, only one truth, that the charges do not stand. I am completely innocent. But I have said it before and I say it again with full conviction. I sympathize with and express my regret for all the victims who suffered in Kosovo regardless of their ethnic affiliation. Your Honours, at the time of the massacres in Chires, Likoshan and Prekaz at the beginning of 1998, I was a student at the University of Zurich. I was not making plans of how to take control over Kosovo. I was making plans to prepare for my exams. The only person who was making plans, morbid plans, was Slobodan Milosevic. Plans for another genocide, a new genocide in Kosovo. That is why, like many other Kosovan citizens, I had been forced to leave Kosovo. Because I was being pursued by the Milosevic regime. It had convicted me in absentia, having charged me with violating its discriminatory laws. Later on, that same regime would also convict in absentia President Clinton, Secretary Albright, Prime Minister Blair too, Chancellor Schroeder, President Chirac, and even the Secretary General of NATO, Solana, and many others in absentia too. Seeing the massacres against my people, like many others, I could not remain indifferent. I decided to return to Kosovo in the spring of 1998. This was an entirely personal decision that I took. It was nobody else's, because I could not stand away whilst my family and my people faced extermination. I did what every one of you would do if your country, if your people were to be living through the same as mine, and for that I am very proud and I shall never regret it. Your Honours, the prosecution claims that the purpose was to gain and exercise control over Kosovo. This is not only entirely untrue and utterly absurd, but it's also deeply offensive. It is an insult to the memory of the thousands of heroes who gave their lives for freedom. It is an insult to the tens of thousands of the victims, innocent victims who were killed and massacred. It is an insult, and it is unjust in view of the efforts of NATO and the Western Alliance, with whom I cooperated closely. Your Honours, allow me to repeat an eternal truth here. My only, and I stress my only opponent of mine, of the people of Kosovo and of the democratic world was Slobodan Milosevic. It is painful to hear this accusation, particularly when I did not know whether I would be alive from 1 hour to the other and from one day to the next during the war. I was not sure whether I would ever see my family again, and my wife or my newborn son, and let alone to dream of exercising control in Kosovo, a Kosovo that was had been under full occupation for around 90 years. The fact that some of us are alive today is purely a matter of chance and luck. I did not return to risk my life for control or for power. I returned to my homeland, risking my life for freedom and for peace. The question that is put today is to take control from whom? From whom? The truth is that all the control and power in the entire territory of Kosovo was in Milosevic's iron fists and nobody else's. Albanians did not exercise any power. That is paradoxical to say. They were being oppressed by the power exercised by Slobodan Milosevic. Our mission as a people was crystal clear: survival, freedom and peace. I did not have a single illusion. But our only hope of salvation was the democratic world, the United States of America and NATO. That is why my entire focus during that time was building and strengthening this alliance. And for that purpose, I traveled to many capitals to persuade them of our just cause. To Brussels, to London, Berlin, Paris, Bern, Oslo, Vienna, and many other places. Wherever I was, however, I was in contact with officials from the American administration. Milosevic had started the war in Kosovo, whereas we, the Kosovars, were defending ourselves. Only NATO could end the war, though, and that is what happened. Had it not been for NATO's intervention, there would never have been any freedom or independence for Kosovo. The independence was not an instrument for power, it was a means for achieving dignity. Your Honours, this prosecution has given me many accolades, given me many titles or ranks. The truth, however, is entirely different. It wasn't I who transported the resistance from the West to Kosovo. I joined the resistance in Kosovo. It was not my return from the West the reason why the KLA was growing in numbers. The reason was Milosevic. And no one has put it better than Secretary of State Madeleine Albright, and I quote, "With his behavior towards the people of Kosovo, Milosevic is the biggest recruiter for the Kosovo Liberation Army." The KLA was not a state. It was not the army of a state. It was a popular organization to defend against an aggressive state. The fact that the KLA was not organized in the way alleged by the prosecution does not in any way diminish its role in securing Kosovo's freedom. It does not make its cause for liberation less noble, nor the achievement of independence less historic. Kosovo's victory was more of a political and diplomatic nature. The greatest success for the people of Kosovo was full cooperation with the West and its trust. They helped us precisely because they were aware of who we were and what our aims were. I would not put at risk this alliance for anything in the world at no price, under no circumstances, because in so doing, I would have imperiled Kosovo's very freedom. I would have put at risk our collective resistance. Our goal was peace. It was not war. When the democratic world decided to convene the peace conference at Rambouillet, we responded to their invitation positively. The Kosovo Liberation Army was one of the three groups from Kosovo represented there, including independent representatives. Throughout the process, however, at Rambouillet and at Paris, we worked together as one single Kosovo delegation. We accepted the peace agreement, even though it did not meet all our legitimate demands. Kosovo chose peace and democracy. Serbia chose war and genocide. And to help the international community, just as they had asked us to, as the West had asked us to, our three groups, the Democratic League of Kosovo, the KLA and the LBD, agreed to form a joint government, which would be operational until the first free and democratic elections in Kosovo. It was an agreement to join forces towards a common purpose, Kosovo's freedom. How can anyone claim today that the goal was to gain control of Kosovo when we accepted that the international community would have the final say in Kosovo? Or that the KLA would hand over its weapons to NATO, which is what came to pass from June to September 1999. After Milosevic's capitulation, Kosovo came under the administration of the United Nations, and that is a well-known fact. UNMIK made it clear since its inception that all executive, legislative and judicial power was to remain in their hands. These were entirely new circumstances. I cooperated with UNMIK afterwards and with other political parties in order to help implement the mandate for the benefit of the people of Kosovo. I cooperated with the joint structures of UNMIK. Honourable judges, during all that time, the only power I had was the power of my voice. Your Honours, as you have seen during this trial, I used my voice to promote a multi-ethnic and tolerant society in my country, in Kosovo. I called the local Serbs to remain in their homes and to build a new life together with us. Like us, the Serbs and the other communities, they were the victims of Milosevic. This was not easy for me to do this after everything that had happened, but it was the just and right thing to do. At a time when fresh graves were being dug around Kosovo for thousands of the victims, for thousands of those missing and not being found, when thousands of Albanians had been taken hostage to Serbia, when pain was deep and collective, what I was doing could very well have had any physical consequences as well as military repercussions for me. But Kosovo was more important than my personal fate. After NATO's entry into Kosovo and the withdrawal of Serbian forces, the citizens of Kosovo were not engaged in a war. They were celebrating the long-awaited freedom. During the 9 years preceding independence, from 1999 to 2008, we were United Nations citizens in our country. During that time, I called on the population to be patient, to be tolerant, to remain united, and to have faith in our international partners. The independence was the fruit of our alliance with the democratic world. After independence, I cooperated with the European Union and the USA as well as other relevant factors in order to normalize relations with Serbia, Your Honours. What we were faced with was not only what occurred during the war. It was a central pressure apartheid. The collective trauma caused strong feelings of anger and revenge, both during and after the war. President Clinton visited Kosovo immediately after the war and told us, "We won the war, whereas you must win the peace." I took this message very seriously, and I used my voice to call for peace, tolerance, and unity. For most of the post-war period until the Declaration of Independence, I was not in power. I was out of power. And when I gained power, that was through the free vote. But throughout that time, I respected democratic norms and the results of elections. And whenever my party was in power, it was always in a coalition with the Democratic League of Kosovo and other Albanian and non-Albanian political parties. And together, we made the state of Kosovo a reality. Your Honours, Russian and Serbian propaganda would not forgive us easily. Having failed to delegitimize Kosovo independence at the International Court of Justice here in The Hague, they turned to the Council of Europe. They revived horrific allegations of organ trafficking. These were allegations that had been previously investigated by the Hague Tribunal, UNMIK and ULEX, and had been dismissed as unfounded. As soon as Dick Marty's report was published, as Prime Minister of Kosovo at the time, I convened key international representatives, the Quint embassies in Kosovo, as well as the leaders of ULEX. I requested another independent investigation. They promised to remove the black cloud hanging over Kosovo. The truth is that the Russian and Serbian propaganda manipulated Dick Marty. He fell a victim of their campaign. They fed him false information and even attempted to kill him in the end in order to frame us. The aim was crystal clear: to discredit the most successful political and military project internationally for over the recent decades, the story of success of Kosovo. When we voted in Parliament to establish this court, in the Kosovo Assembly that is, we believed that it would address the allegations contained in Dick Marty's report, and it would operate in accordance with the Constitution and the laws of the Republic of Kosovo. None of this happened in practice. I was criticised heavily in Kosovo, and still I am, for supporting the establishment of this court. The critics say that this court aims to criminalise our war for freedom and the idea of independence. I did not believe that at the time we voted, and I sincerely hope that time will prove me right and that the critics were wrong. Instead of removing the black cloud hanging over Kosovo, this prosecution seeks to block out the sun with a black storm. with the so-called joint criminal exercise. Many of the allegations that I've heard from this prosecution, Your Honours, heard from the prosecution in this courtroom are the same that I've heard during election campaigns in Kosovo. It is a painful truth that this prosecution attempts to dismiss the testimonies of senior NATO officials from the United States, the United Kingdom and the United Nations. The testimonies of those and their people who were with us on the ground at the time, those who were the eyes and ears of the Western Kosovo. Worse, this prosecution claims that I misled the internationals during the war. This is ridiculous. It seems the prosecution once again gives me more credit than I deserve. On the other hand, however, this prosecution extols to the skies the fabricated evidence from the era of the regime of Slobodan Milosevic, and in doing so, it ignores the truth. Your Honours, in the end, 2 minutes maximum. My commitment to justice and to the victims has been ongoing and steadfast. In Rambouillet, I supported the request of the Tribunal for former Yugoslavia investigate alleged crimes by all sides, and since the end of the war, all powers for investigating war crimes were in the hands of the internationals. ICTY and Mick and ULEX, who I supported. No one accused in Kosovo for war crimes has evaded justice. Not a single window pane has been broken to oppose legal proceedings during the 25 years after the war. After the independence, when I was Prime Minister of Kosovo, I agreed that independent investigations into war crimes should remain in ULEX's hands. And as President of Kosovo, I engaged eminent international and local experts from all communities to create a transitional justice forum for victims, the Truth and Reconciliation Commission. But the truth is that justice for the victims cannot be built by pursuing the innocent. Reconciliation cannot happen through selective and mono-ethnic prosecutions. Your Honours, my last sentence. Throughout my life I stood with the people of Kosovo, defending freedom, life and dignity. I was always guided by the Western ideals of democracy, equality and justice. Today, at the end of this trial, I have only one plea for you, Your Honours, that your judgment be guided by the Constitution of Kosovo, the law, the evidence and facts. The evidence presented here makes it very clear that the charges do not stand, so the only just decision would be my full acquittal. Thank you very much.
Mr. Vasily, you have the floor.
Microphone seems to be off, please. I apologize. My mistake. Apologies. Once more, greetings to everyone in the courtroom. Greetings to our guests in the public gallery. Greetings to every citizen of the Republic of Kosovo. Honorable presiding judge, honorable members of the panel. At the end of my trial, I'm addressing you to stress one single but extraordinarily important point. The court must, in any circumstance, defend justice, truth, and impartiality. This is not merely a legal duty. It is great contribution and legacy. This is also the reason why I joined those thousands of women and men who joined the ranks of the Kosovo Liberation Army for the freedom of Kosovo. And I have dedicated my entire life and served my country in order for any citizen to enjoy justice and for the world to know the truth of our nation. Even in the darkest of the moments, I never lost faith that what is right, the truth, and freedom would triumph. I always believed that the people of Kosovo, like any other people in the world, had the inalienable right to live in freedom and with dignity. I believed that the suffering would end and that justice would come about, even though delayed. At the same time, I never believed that hatred, violence, or revenge can be honorable guidance. They cause destruction to the soul of the peoples, and not only to the victim. Hatred is another form of slavery. Freedom cannot be achieved through injustice, nor can peace be built on crime. A right cause cannot be defended through wrong means. This, for me, was not only a theoretical principle, but a deep moral conviction that guided every action I undertook. My family and I have lived constantly under persecution by the Serb state. This is not an abstract description, but a concrete reality that affected each and every member of my family and my people. The men, women, and children, with no exception, were faced every day with injustice, fear, and lack of safety. I know what it is and what it means to not be protected. I know what it means to live under constant threat. I do not wish anyone to experience this. But this taught me a substantial truth. In the face of injustice, a man must preserve moral integrity and fundamental human rights and values. Some may ask, are these only words, or were they reflected in my life and actions? My answer is very clear, not only in my words, but above all in the evidence presented to this court. After decades of investigations, documents, and countless evidence, there is no evidence indicating that I have committed any crime. It was not established that I committed any unlawful action. This is not a matter of interpretation, but it is a matter of facts. With respect to my involvement in war, it did not stem from a desire for conflict. As a young man, I also wanted a simple life, to live in my country with dignity and in peace with my family. I was a student when the autonomy of Kosovo was abrogated and when the university was attacked by Serbian forces. I took part in peaceful activities to protect our basic rights. But we were denied all these rights. The autonomy of Kosovo was removed, and we students were expelled from our faculties and dormitories, and our professors as well. Our people was denied the most basic opportunity to live as free citizens and equal citizens. Now the whole world knows the truth of what happened. Serbia and Slobodan Milosevic were seeking control over all the peoples of former Yugoslavia. This pattern then led to the wars and hatred in former Yugoslavia, which eventually led to its own destruction. In the beginning of the 90s, I left for Switzerland. I did not leave by choice, but seeking an opportunity for a normal life, for a future built on knowledge and progress. But while I was living in a free country, my country was going through deep suffering in slavery. The situation in Kosovo turned into denial and exclusion of the majority. After the Dayton Agreement, Albanians in Kosovo, as a majority, were left excluded. They could not live freely, but only under threat, intimidation, and terror. In the beginning of 1998, I was at the University of
Freiburg in Switzerland when the massacre of Likoshan occurred. This was a heavy tragedy and cruelty that should have never happened in Kosovo. The tragedy in Prekas on the 5th, 6th, 7th March 1998 was not an isolated act, but the continuation of the massacres committed by the Serb forces. Such acts of terror exceeded the normal fear of the ordinary people and the fear of intellectuals and politicians in Kosovo. The terror and massacres like those in Srebrenica had started happening in Kosovo as well. I could not stay indifferent while my people was faced with destruction. For me, life had a meaning only if my people could live in freedom, and this is the reason I returned to Kosovo. Not as a trained soldier, but as an individual who was still studying, not with hatred, but with conviction. I returned because I felt the moral obligation towards my country. I returned because I could not remain indifferent to the suffering of my people. My intention was clear, to contribute to the freedom and justice of my people, but not to cause any injustice to anyone. I saw these recent months in this courtroom how lightly some underestimate the difficulty of ending a conflict and achieving peace. But history teaches us that those who achieve peace often are faced with the consequences. Looking at today's reality, when the world needs so much peace, it is clear that it is not always easy to achieve it, or to preserve it, and to preserve it is even more difficult. Honorable trial panel, the establishment of this court and its functioning to this day is the result of a broad debate in my country. But above all, what must prevail in this court is justice and impartiality in judging the truth and the objective reality in which we lived and acted. I stand here in these proceedings with a convinced and believing that there is no reason for the truth to be afraid of justice, and that justice may be delayed but never denied. I have lived with this conviction, I have acted with this conviction, and I stand today with this conviction. And I can certainly say, I know who I am, I know what I have done and what I have not done. My actions have been humane and lawful. My conscience is clear, my history is transparent. Now everyone can see and recognize it, including in these criminal proceedings. At the end of my word, honorable trial panel, and respectfully to everyone here and out of the courtroom, we may not agree, but I want to stress, we all are human beings whose dispositions and opinions may be influenced or are influenced by those who surround us and the environment we live in. My belief in the truth and justice remains unwavering, and I want to strongly believe that in your decision, the truth, justice, impartiality, and the law will prevail. Honorable trial panel, yesterday was the Independence Day of my state, and I have a last word for my citizens, the citizens of my country. Happy Independence Day. May God help Kosovo and its good people. I wish to have a special word for a friend of mine, Andrew Strong, who's not with us anymore. I want to thank him, thank my team for their professionalism and their work representing my defense. Thank you.
Thank you, Mr. Vesely. Mr. Salimi, you have the floor.
Honourable members of the trial panel, Mr. President, Let me greet my friends and family in the public gallery, as well as all the citizens of the Republic of Kosovo. This is the third and I hope the last time that I take the floor in this courtroom. More than 5 years have elapsed since the start of this trial. These 5 years have not been easy for us, nor have they been insignificant for the history of our country. Nevertheless, let all of this serve as a good opportunity for justice. After all these years, there is a positive element. I hope that the trial panel has had sufficient time to understand that our war was a just war and that the allegations of the prosecution do not hold. In my speech in this courtroom in April 2023, when this process had only just begun, I said that I was facing an unfounded indictment, and after all this entire journey today, the course of these proceedings has proven me right. The charges against us are entirely unfounded and unjust. I am not taking the floor here today to defend myself. My lawyers do this best, and they have done it here. I'm not here to teach you about justice either, because you know it better than anyone else. But I am here today and taking the floor to ask you to exercise it, to exercise justice. Although nearly 3 years have elapsed since the beginning of this process, the prosecution has continued to rely on claims that have no basis in truth, and on a persistent attempt to sustain a war that was in essence a war of liberation. Although, since it's the very beginning, the pre-trial brief to its closing statements, the prosecution has said that it is not seeking the conviction of the General Staff. Throughout that time, though, its main target has remained the General Staff of the KLA, the Kosovo Liberation Army, as well as Kosovo's independence. At times, in fact, it appeared as if independence itself was being treated as a joint criminal enterprise. In its attempt to assign responsibility to the General Staff of the KLA, the prosecution advanced charges as, and I cite, the General Staff sought independence, or the General Staff declared that it would not support autonomy, unquote. It is difficult to understand against whom this indictment has been directed: against us, with allegations of having committed concrete actions, or against us because we fought for the independence of Kosovo. This remains for you to assess, dear members of the trial panel. Equally problematic is the prosecution's attempt to divide Kosovo society into two camps: those who supported independence and those who supported autonomy, as if it is determined at all costs to create rifts amongst the citizens of Kosovo. And to illustrate it, let me paraphrase what the prosecution stated during the closing statement last week, and I quote: "The General Staff sought Kosovo's independence. Political parties that supported autonomy were considered traitors." In Kosovo, there has never been a single Albanian political party that opposed independence, and therefore none that supported autonomy under Serbia. All Albanian political parties supported independence, which was also the aim of the Kosovo Liberation Army. To portray support for independence as a radical demand and autonomy as modern is an assault not only on Kosovo's history, but also its future. It's as if the prosecution wants to divide us amongst ourselves and to equate the KLA with the crimes of Serbia. No one can do either of those. the war of liberation cannot be equated with the murderous state of Serbia. To equate the resistance of an oppressed people with a criminal plan is to put the resistance of the oppressed on a par with the project of the aggressor. This is not only inaccurate but profoundly unjust. To deliberately attempt to alter historical facts through distorted claims is simply an attempt to rewrite history. The history of Kosovo cannot be rewritten, least of all in a courtroom. The history of Kosovo has been written by its citizens with their sacrifice, by its fighters for freedom and its fallen heroes. When Serbia and Milosevic were killing my peers, poisoning pupils and students, dismissing our parents from their jobs, closing schools and hospitals, hunting us down in order to kill us, and carrying out ethnic cleansing and genocide, what were we supposed to do? Stand still? Serbia never concealed its aim against Albanians. In this courtroom, we heard the testimony of General Clark, who recounted a meeting with the Butcher of the Balkans, where he openly declared his intention towards Albanians. We, and the opinion following that testimony, heard the NATO general when he said, and quote, "Milosevic told me, we know how to deal with the Albanians. They must all be killed." We knew this too, because Serbia never hid its intention towards Albanians. So I ask one more time, what were we supposed to do? Wait our turn to be killed? Or flee the country and our homes? Not one and not the other. We had to resist. That is why I believe that Kosovo needed to defend itself. It needed people ready to give their lives for it. It needed someone like Adem Yashari and the Kosovo Liberation Army. That is the reason why I joined Adem Yashari. The Kosovo Liberation Army was not created out of pleasure, but out of necessity. It was a response to systematic violence and denial of dignity. It was not an adventure. It was a means of survival. Honourable judges, I was part of a volunteer army, 100% volunteer army composed of civilians, teachers, students, farmers, workers, parents. These were people who were forced to take up arms because they had no other alternative. In some of its submissions, the prosecution, in a strange way, in a strange effort to accuse me, described me as somebody close to Adem Yashari, as well as an organizer who enjoyed respect. It is unclear on whether this was meant as an accusation or as praise. For me, having been a fellow fighter of Adem Yashari is the greatest honor that could be bestowed. Likewise, I consider it an honor to be described as one of the founders of the KLA. If these descriptions are translated into accusations, the problem then does not lie with me, but with those who treat honor and historical responsibility as guilt. Yes, it is true, I did carry weapons. Weapons was a means of survival for us. Many of my fellow fighters died in the process of procuring them. We sought help for armaments from friendly countries, including the United States of America, which has been heard in this courtroom too. The KLA had no other aims apart from freedom. It did not have any plans to attack civilians or political opponents. The Kosovo Liberation Army was not a political party. It was a liberation army. Even if war in Kosovo had not ended in June 1999, it had continued until today, I would still be a soldier in my own homeland. obviously assuming I had not been killed by now, which was highly likely. I am convinced that I did the right thing. I would do the same thing. Freedom, peace and democracy are achieved by fighting against aggression. That is why NATO supported us. That is why your country supported us. In its final brief, the prosecution seeks extraordinarily harsh sentences so long that they effectively aim to permanently prevent us from returning to our own country. When my return on Kosovo now depends on your decision, but the prosecution ought to have understood that whenever I return, I shall return to a free Kosovo, to a Kosovo for which I'm proud to have stood up for at the right time, and for whose freedom I have been and remain ready to give my life time and time again. With all due respect for each and every one of you in this courtroom, I believe that if your countries had experienced similar circumstances to the ones experienced by Kosovo, you'd have acted in the same way. I'm convinced that you would have fought for your people and for your country, just like your predecessors before your own countries became free and democratic. Many things happen during war. There is chaos, fear, individual actions, and pain that accumulates over years of oppression. War tends to always leave behind consequences and victims. It is these victims that need justice based on truth. Justice that is not based on truth harms victims a second time and destroys its own purpose. After everything we've heard from the parties over these years, my request is fairly simple. That your decision be based only on what has been proven, not on what has been advanced, on facts, not assumptions, on laws, not on impressions. I'm fully confident that justice and only justice would enable us, the accused here, to return to our own homeland. Finally, I wish to thank our defence teams, and in particular my own team led by Geoffrey Roberts, for their professional commitment in defending me, in defending justice, and above all, in the defence of our just war. Above all, I thank our fellow citizens who believe in our innocence. Their support has made the shackles that have weighed on me feel less of a burden, particularly as those are no longer shackles that weigh on Kosovo as they did throughout the time that it remained under the brutal occupation of Serbia. It's often said that people who do something right by their homeland are fortunate people. I appear to be one of them. Thank you.
Thank you, Mr. Salimi. Mr. Krasniqi, you have the floor.
Honorable Presiding Judge, honorable judges, and through you I also greet the people of Kosovo who yesterday celebrated their independence, citizens who live in freedom, independence, and justice. I stand before you today not as a criminal, as described in the indictment of the prosecution, but as a man born and shaped by the struggle for human dignity, by a people who refuse to disappear as a result of the criminal and genocidal politics of Serbia. I have spent most of my life guided by the belief that human beings deserve to live in freedom. After more than 5 years of unjust imprisonment and, in my view, unnecessary, my lifelong political commitment to life and freedom has been constant and early. And to offer a truthful account of our struggle for independence against the policies of persecution and genocide by the Serbian regime that brought untold suffering and destruction to the people of Kosovo. For more than 5 years now, it is my belief that I have been denied the human rights provided for in the European Convention for Human Rights and Fundamental Freedoms. Among these, the most important is the right to live in freedom, especially the right of a man in the final stages of his life to live the remaining years in dignity and with his family and in his free country. This has been done to me without my causing injustice to anyone or endangering anyone's life. Rather, I risked my own life, not only during the Liberation War, but since the 1973, together with my family and my fellow countrymen and my fellow villagers. We believe that the darkness of injustice would break with the dawn of hope. This is why I was committed to liberation and equality for all. I emphasize in particular the period after 11 June 1998, when I came out openly with my full name and without a mask as the spokesperson of the KLA. The risks were immense, but I was not concerned about my safety because I was driven by my commitment and dedication to all citizens of Kosovo and their future. Today, I am in my 16th year of imprisonment, solely because I fought for the freedom and independence of my people. I said 16th year because I have spent more than 10 years in prison from 1981 to 1991. To have spent 16 years of my 75 years in prison and deprived of the air of freedom is not something small. It is something huge. My public appearance on 11 June 1998 showed that I was an opponent of Serbia's genocidal policies and came shortly after the massacres committed by the Serbs in Čirez, Lekošan and Prekaz, where 83 people lost their lives, most of them unarmed children, women and elderly people killed in their own homes. Those brutal murders marked a turning point of conscience for an entire generation of Albanians. What drove me to take this extremely dangerous act for that time? Long captivity, persecutions, expulsions, numerous imprisonments, and uninterrupted execution and killings that marked the entire 20th century. These cruel acts did not break me. They made me determined that justice shall not be broken on the back of tyranny that we experienced. Love for life and freedom made me take up this role. A man does not choose resistance lightly. He chooses it when every other door to dignity has been closed. I was denied and prohibited the most human right of any person born free. And any reasonable person who knows the value of human dignity and the equality of all. The right to love my country openly, to work for it, and to pass on what I learned through decades of sacrifice. For these virtues, I was handcuffed on 4 November 2020. The prosecution's accusations against us and the KLA are built on the narratives of those who led several wars across the Yugoslav Federation within a single decade. I do not believe that this accusation serves any justice, especially not the justice that democratic societies claim to defend. Justice cannot be built on the language of former oppressors. It must stand on credible evidence and truth. The unfairness of this case is written into the indictment itself. I was assigned roles, authority, and responsibilities that I did not hold. This was not a matter of difference in interpretation of facts. It was invention. The figure described on prosecution papers is not the man who stands before you today. I am grateful to those witnesses who came here and had the courage to speak the truth about who I was and who I was not. They came not to protect me, but to protect the facts and our historical reality of Kosovo. Their testimony confirmed a simple reality. I did not possess the power, the command, or the functions that this case attributes to me. When the truth is spoken plainly, it requires no decoration. The whole world knows that NATO intervened against crimes committed against the Albanians of Kosovo. NATO and the democratic world has never aligned itself with terrorism or genocide. Without the international intervention and support, our freedom would not exist. But without our nobler resistance, it would never have been achieved either. The actions of the KLA and my actions, both during the war and after it, in every case gave priority to peace, and this has been proven. Credible voices have testified to it. We stand here today unjustly, but history will remember why we acted, and not merely that we are accused. I must speak about the historical reality that surrounds this case. The crimes and persecutions by Serbian forces that shaped that period are inseparable from the actions that you are asked to judge. They are not background noise. They are written in public history in letters too large to erase. They remain part of the reality that you are asked to judge. I join my lawyers in asking you, honorable judges, to hold that history firmly in mind, because judgment without context risks mistaking consequence for cause. Please do not make that mistake. Our struggle was not unique in history. Every nation that has sought freedom from illegal apartheid-like occupation has faced the accusation that resistance is criminal. Yet, international law affirms that people who resist systematic persecution are not enemies of justice. They are invoking the very principles upon which justice stands. Our generation had a vision: life in freedom, for equality, democracy, and the rule of law. It is that vision that led the struggle which culminated in Kosovo's independence, declared on 17 February 2008. Dear judges, our people have never sought the destruction of another nation, ethnicity, or religion. We fought only for life, freedom, democracy, equality, and justice. Not to control territory for domination, for greed, or criminal gain. Our purpose was to return Kosovo to its people, to all of its people, so that they could live in dignity and safety and with equal rights. Any accusation that says the contrary is to further the lies produced by the Serbia's criminal regime. For all my political activity, honorable judges, I am truly proud. My voice stood for freedom. I did what I believed human nobility required. Not a single witness has said otherwise. I ask you to view the evidence and testimonies objectively, and there you will find the truth. Justice does not fear scrutiny, it depends on it. Honorable judges, I repeat respectfully again, our people never planned destruction or torture. We sought life in freedom and independence. Nothing more, nothing less. Today, our people live in freedom. If loving freedom is judged as a crime, then history itself will stand condemned. I stand before you as I have stood all my life, accountable to truth and unafraid of it. I gave my life to the belief that people deserve freedom. If that belief is judged as a crime, then history itself will deliver its verdict long after this court has spoken. I ask you to judge the evidence patiently and without predispositions, and you will not find a criminal enterprise, but a human story shaped by hope and necessity, and the belief in freedom and democracy. If that belief in our freedom is judged fairly here, then justice will not only serve me, it will honor the principle that brought this court into existence. I will finish my word here, asking for justice, which is obvious. Thank you for your attention.
Before closing the case, I need to ask, do any of the parties or participants wish to raise any further matters? SPO?
None, Your Honor.
Victims' Counsel?
No, thank you, Your Honor.
Anybody from the defense?
No, Your Honor.
No, Your Honor.
No, Your Honor.
No, Your Honor.
Before I close the case, I remind the parties and participant that pursuant to Rule 136, no further submissions or evidence may be made to the panel at this stage unless in exceptional circumstances and on showing of good cause. This, of course, does not include matters that must be regularly reviewed, such as detention. The panel wants to thank all counsel and those who assisted them for their individual and collective contribution to this case. We felt greatly assisted by your contributions in ensuring that the proceedings were fair and that the defense of the accused was effective at all times. The panel also thanks the Court Management Unit for their excellent work and for the 24/7 availability throughout this case. This panel is also grateful to the court reporter, the interpreters, and all involved in the units of the registry for their assistance. The panel will be in touch with the parties and participants in due course regarding the date of rendering of a judgment. So pursuant to Rule 136, Paragraph 1, this case is closed. And we are adjourned.
All rise.